So, can you be guilty of a crime that never actually happened? I know, it sounds like a riddle, right? But it's a very real legal concept. And today, we're going to break down the fascinating law of criminal attempt.
Okay, before we dive in, we've got to do the quick legal thing. This is all for educational purposes, and it is definitely not legal advice.
All right, let's get back to that riddle. What happens when someone plans a crime, they start to carry it out, but they don't finish? Maybe they're stopped, maybe they fail. Well, this is exactly why the law of criminal attempt exists.
So here's our game plan. First, we'll look at the actual law on the books, PC 664. Then we'll get into the two-part test the courts use. After that, we'll talk about that blurry line between just preparing and actually doing something criminal. We'll also bust a couple of common myths about defenses that don't really work. And finally, we'll nail down the key takeaway.
All right, let's jump right in. We're starting with the legal foundation for all this stuff here in California.
This right here is Penal Code 664. And you know what? It's actually pretty straightforward. It basically says that the act of trying to commit a crime is a crime in itself. It doesn't matter if you fail or if you get caught before you can finish. The attempt alone is the crime.
Okay, so how does a prosecutor actually prove someone was trying, right? It can't just be that you were thinking about it. And it's not. Courts use a really specific two-part test to figure it out.
And here it is. For an attempt to legally count as a crime, a prosecutor has to prove two things. Number one, a specific intent to commit a crime. That just means they really, truly meant to do it. And number two, they took a direct but ineffectual overt act. Whoa, that's a mouthful. All that means is they took a real, concrete step towards making it happen, even if that step ultimately failed.
This really helps visualize it. On the one hand, you have specific intent. Think of this as the guilty mind. It's what's going on inside someone's head, the decision. But, and this is super important, a guilty mind by itself is not a crime. The law needs that second piece, the overt act. You can call that the real step. It's an actual physical action that starts to turn the thought into a reality.
And this, right here, brings us to probably the trickiest part of attempt law. Where exactly is that line between just preparing for a crime and actually attempting it?
So let's look at this line. On one side, you've got mere preparation. This is stuff like, buying a ski mask, looking up a bank's floor plan. At this stage, it's all just thoughts and planning. It's not a crime, yet. The line gets crossed when you commit an overt act. That's when the plan goes into motion. So it's not just buying the mask, it's putting on the mask and walking towards the bank. That's the step that crosses the line. And there's a really good reason the law is set up this way. This quote from a famous case, People v. Dillon, says it all. Basically, if the law had to wait until the trigger was pulled or the money was grabbed, well, the law of attempts would be pretty useless, wouldn't it? The whole point is to give law enforcement a chance to step in before someone gets hurt. Now, here's a really critical idea. Think of it like a balancing scale. The more evidence there is of someone's intent, their guilty mind, the smaller the physical act needs to be to count as an attempt, right? If the police have text messages, a detailed written plan, maybe even a recording, well then even a seemingly small first step towards that plan can be enough to be considered a criminal attempt.
At the end of the day, the courts try to apply common sense here. This quote from another case, People v. Memro, really nails it. The point isn't to get bogged down in tiny philosophical debates. It's about looking at all the facts in a practical way and asking, what was this person really up to?
Okay, so what about some common scenarios? Like, what if someone starts to commit a crime but then gets cold feet and backs out? Or what if the crime they were trying to commit was actually impossible from the start? Let's dive into a couple of arguments that people think are defenses, but, well, usually aren't.
First, let's talk about abandonment. This is exactly what it sounds like. Somebody has taken that direct step. They've crossed the line from preparation into action. But then they have a change of heart and decide, nope, not doing this, and they turn back.
So, is that a defense? In California, the answer is a clear no. The law says once you commit that overt act, the crime of attempt is already complete. It's done. Changing your mind after the fact doesn't erase the crime that's already happened.
All right, the second big non-defense is something called factual impossibility. This is when someone tries to commit a crime, but for some reason they don't know about, it's literally impossible for them to succeed. The classic example is trying to pick someone's pocket, but oops, the pocket is already empty.
And just like abandonment, this is not a valid defense. You might be asking why. Well, it's because the law is punishing the guilty mind and the real step that was taken.
It doesn't really care that the circumstances made it impossible. The fact that the pocket was empty doesn't change the fact that you tried to steal from it.
Okay, so we've gone through the law, the two-part test, and a couple of defenses that, well, don't work. Let's wrap this up and boil it all down to the most important things to remember.
So here's the bottom line. Criminal attempt is really just the crime of trying. That's it. It always needs two ingredients: that guilty mind, the intent, and a real step, that overt act. The second your preparation turns into actual action, you've crossed that legal line. And remember, once you're over that line, getting cold feet or discovering your plan was doomed to fail doesn't give you a free pass.
And that leaves us with a pretty tough question to think about, doesn't it? If someone's intent to commit a crime is absolutely crystal clear, how small can their action be before it's considered a crime? Where do we draw that line? That's really the central challenge of this area of law, trying to strike that perfect balance between stopping crimes before they happen and making sure we're not just punishing people for their thoughts.